Welcome to Connections and Conversations, an advocacy arena podcast, working to increase civic engagement and strengthen our communities. Well, hello, my friend. I am so glad to have you here again on Advocacy Arena. Folks, I have with me Marc G, a law professor, a former prosecutor, and a frequent contributor to our weekly Good Trouble chats, giving us all the legal updates. One of the things that I learned about Marc when I first met him, and you'll soon find out, is how passionate he is about the law. So I could think of no better person to have come and talk to us, being as how in this new iteration of this regime, we have all sorts of cases swirling around. And these are monumental because I looked at them, and of course, he's gone after law firms, he's gone after institutions, he's pouring out all these EOs, which are quickly met with a lot of backlash. And I just wanted somebody to come and talk to our audience about that, who could speak to it in a way that you do, Marc, because you do it so well. One of the only people I know who can speak legalese, help us to understand in such easy to grasp layman's term. So I'm going to ask you, first of all, to just say hello, and then, the kind of cases and things that I had told you I wanted to dig into. So wherever you want to start from there, and I have some questions around all of them. So thank you for being here.
Dee, it took us a little bit to get connected here.
Yes.
Thank you so much. Again, this is I think our second interview. I love your advocacy arena because I get to talk off the top of my head and just go in. I thank you for allowing me to do that, being able to communicate with folks, just stuff that I think is important, but also educate people on basics of civics and constitutional law in ways that people can understand. I'm a law professor at heart. I teach undergrad locally and hopefully might be at a bigger school sometime soon.
Okay.
But I do love teaching folks, and I like talking about these major issues that none of us really knew were going to be major issues in law when I went to law school almost 30 years ago. I didn't know that I'd be here with you breaking down these basics of con law, and then also discovering the arrogance of even saying basics of constitutional law, because there's nothing basic about it. It's a very complex group of laws. Constitutional law is very nuanced and complex, and it's hard to understand. So that's why we talk every week about the meanings of some of the things that are happening, not just with the Supreme Court, but also with some of the district court orders.
Yes.
That's been coming down since we've been on Advocacy Arena since the beginning. I think it's very important.
Absolutely. And one of the first things that I wanted to talk to you about, especially from your perspective as a professor of law and someone who has practiced as a prosecutor, the assault that is being carried out on these law firms, and just our institute kind of ignoring the courts, all of these things. Like, how do you feel about, again, from a lawyer's perspective, about the capitulation of some who are in the profession?
That's good. I'm glad you started with the easy one first, right? Some of these law firms, I know, some law firms are capitulating to the president's power because they have government contracts and money talks. But let's back up. What happened? In early 2025, Trump signed executive orders that barred federal agencies from working with law firms that had challenged his policies in court. It hit major law firms like WilmerHale, Jenner and Block, and Sussman Godfrey, and some other big, huge law firms. These are juggernauts. The reason why he hit them is because some of them were involved in many cases that involved him as a defendant, or some of the lawyers that they hired involved him as a defendant. And so it's punishment. So who cares about big law firms, right? Nobody really cares. We should care, though, because these law firms are suing the government now. Some of the good ones, like the ones that capitulated, I can't speak for them. Money talk to their partners, and partners care about their money. But what the little law firms are arguing there's something called the First Amendment. Free speech and legal advocacy is protected by the First Amendment.
Right.
And there's also due process. And due process is a word that's just like being thrown around, and like people don't understand. They think it's a trial, they think it's some big thing. It's just notice of what you did wrong and the opportunity to be heard and say, I didn't do this wrong. So it's notice and opportunity, or notice and a hearing,
Mhm.
or don't punish me without a fair hearing. And the principle is this: lawyers have to be free to represent popular and unpopular clients without government retaliation. And that's what we're talking about.
Vigorously.
Right.
I mean, you want your attorney to represent you in that way.
Correct. And what theme that we're going to come back to in this talk, and you're going to hear me say this over and over, and you probably heard me say this yesterday on Advocacy Arena, is rule of law. I was on other pods on Spoutable, which we're both on, which is run by Christopher Boozy. It's spoutable.com. Everybody should get on that so you can hear more of D and me on Advocacy Arena on Mondays at 12. But rule of law is the cornerstone of our democracy. It's the idea that no one, not even a president, this president, can punish you for just defending someone the government doesn't like, or participating in a prosecution of a president who broke the law criminally. These cases, like this case and the other things we're going to talk about, this is central to our functioning democracy, because it's an attack on our lawyers that, whether you like them or not, they're arguing law, and they're arguing before courts about rule of law. And I think that people need to understand there's a difference, because, a lot of people are disappointed by rule of law. What I teach and what I say is that there's a difference between rule of law and also a difference between application of law, right? Rule of law says that this president committed a crime
Mhm.
and he needs to be prosecuted. Application of law is when we have Merrick Garland, who waits 2 years to appoint a special prosecutor. So we can discern from rule of law. Don't knock the message, knock the messenger. Application of the rule of law is where our problem lies, and why Trump was not held accountable in the first place.
Absolutely. And I love that you broke it down in that way because, yes, he was prosecuted. He had broken laws, but the manner and the timing of which it was applied, the accountability led us to this moment where essentially he got off. He was able to get away with these things. And in so doing, now is just running roughshod over the country and trying to do the same over the courts. And that's a very dangerous place for us to be because, as I said to you, I see three alarming dangers going on here with all of the legality of it all. That's him attacking the rule of law and then also trying to attack and suppress the modes of education that we, the people, have. And you always talk about us being a democratic republic, which means it is a representative government, and we get to vote to decide on those representatives. So, another one of these EOs that he has passed is targeting our elections. So, I feel like he is crippling intentionally our democratic republic, our democracy. That's it. When those things don't work, we are no longer a democracy.
I'm glad you brought EOs up, executive orders. And I like to break things down. And that's why I love teaching undergrad. I don't have arrogant law students like I used to be, challenging, asking what I call stupid questions now, but they're not stupid questions.
Questions need to be
I
asked.
like the undergrads they're just sponges for knowledge, man. I love the undergrads in pre-law more so than when I guest lecture at Pepperdine. I get these crazy challenges to my academic prowess, and we lose sight of what we're talking about. But with regard to the executive orders regarding elections, let's break down what executive orders are. They're just letters, and they're not law. Executive orders are not law. The President of the United States, no matter who it is, has the power that is given to him by the Constitution in Article 2 or by Congress. And that's it. That's all the powers of the president. It's in the Constitution in Article 2, or there are powers that are delegated to the executive, the chief executive of the executive office by Congress. The president has no other powers. If Congress hasn't done it and the Constitution doesn't call for it, the president can't write a law. The sole arbiter of law writing belongs to Congress. Congress writes the laws from Article 1. It's the first article, the first thing that the founding fathers, if you will, wrote down is Congress. And actually, there was only one body of Congress originally. And there was a great compromise, and they split it into a bicameral institution, meaning they had a Congress, a House of Representatives, and a Senate. It used to be just a Senate, but the House of Representatives were there because the South made a big deal. There was a great compromise, and that gave us the Madisonian democracy that we have, where we have a House of Representatives and we have a Senate, because at that time there were more people living in the North than in the South. They had a House of Representatives and not a Senate. They had a Senate because of the South,
They could have it be equal.
and bills had to pass both houses because more people lived in the North than lived in the South. So more people, more representatives. The House of Representatives had a more majority North. So that's how we got a bicameral House. And they call it bicameral. I don't know why they call it that word. That's what they call it, though. And so when they write a law, they say the president can do this under the Constitution. The president enforces and administrates the law. Enforces the law that are written by Congress, administers the law written by Congress. The judiciary, which is a co-equal branch of government, interprets the law based upon the Constitution. So they throw the law against the wall and say, hey, this is either constitutional or unconstitutional. This is not what the founding fathers had in mind. So when a president writes these executive orders, like for instance, the executive order regarding elections showing ID, that's just a letter. It's worthless. It's not a law. As a matter of fact, federal elections, even though there's a federal input regarding elections, each state is constitutionally responsible or has the power over its own way to administer elections. Each state can do elections in a manner that they see fit, as long as it's constitutional. They can't, for instance, we learned in 2020, a state can't not like the results of the election and then decide that they're a majority. They want to send different electors to Congress to represent the party that lost. They can't do that. So the feds will jump in there. But the manner in which a state conducts their elections is up to the state. For instance, little things like counting ballots. A state can do hand ballots if they want, or they can do machine ballots. That's totally within the prerogative of a state. So I want to get back to basics on that. So when we talk about Trump writing these executive orders, they don't mean anything. And they're going to be challenged because what's the issue? The issue with regard to Trump is that, after the 2024 election, local officials tried to block certification of election results, even though there was no evidence of fraud. Excuse me, 2020. They tried to block certification of election results, even though there was no evidence of fraud. And we see this machination of an effort to do the same thing. Election certification is not optional. It's not something that is a choice. It's a ministerial duty. And ministerial means, it means that, like, you know what? It's not like, hey, I want salt and pepper on my eggs. It's like eggs come with salt and pepper. That's it. That's the only way you can get eggs in this Constitution. It come with the salt and pepper. So officials are required to sign by law, sign off on the vote counts. And also identification and things of that nature are decided locally. The president can't decide how a state does this election. We're not going to really touch on this, but this applies to federal laws too regarding immigration. We hear a lot of talk from, I call it the Ministry of Lies and Propaganda, that comes from the White House. It's a second coming of Joseph Goebbels' ideology in Nazi Germany.
Absolutely. We started with alternative facts from the previous one that
Look where she ended up that quoted it. Little did we know that we were headed here. Alternative facts are their thing. It's the Ministry of Lies and Propaganda. So we go back to that, and like we're talking about them lying about this entire process, not only the election, but lying about how the process works. And so the legal consequences. Undermining our electoral institution is election subversion. I call it election subversion. because it's an attempt to overthrow valid results through pressure, delay, and refusal to follow the law. Like I said, everything from the beginning of this conversation all the way to the end of it is going to connect like a constellation. And that's how I like to look at the rule of law, as not a bunch of stars in the sky, but a constellation that makes up a picture. And when you see the picture, you understand. So when I talk about, I call it data points, if you will, or star, I call them stars. This is another data point about a picture that this administration is trying to subvert our republic and through the election laws as well, refusing to follow the law.
Republicans have a history of this subverting of elections. I mean, like the suppression of votes and the things that they did during the Jim Crow era. Those things are just, I feel like, that local level example. But of course, we had a civil rights march and got some of those things corrected. And it seems that what they're doing now is essentially rolling back, erasing all of that. And this is just kind of a new version of that being federalized, nationalized.
To that point, the Constitution requires each state to provide a Republican form of government. Now, it doesn't mean the Republicans. We are a constitutional republic. So, what that means is counting votes fairly. Everybody that can vote should vote. And then when we count them fairly. So, it's pretty simple what the founding fathers put out there. And they were able to do these votes without any big problems when sometimes it took a month to get votes back to the Capitol.
Right.
That's actually why they have, I mean, just a little constitutional history. Why we have the election in November and then why there's no certification till January is because it took a couple months for the carriages to get to DC to deliver the ballots.
Well, I love nerding out on some history.
Yeah, yeah. As the country expanded to the west, those votes were late coming in, so they had to certify those votes, have them in the DC by January 6th. Sometimes it took a month or two to get through the winter and get to DC so that the vice president could certify the votes. That's why we have people like, how come there's such a delay? After November, then we have December. Each state has to certify their election. That's federally mandated on federal elections, and then a whole nother month to get the letter, the literal electors signed in a letter under oath to DC, to the vice president for that bicameral Senate confirmation where House representatives or senatorial people can't object and they have the whole objection scenario. But that's why there's that process. Going back to the beginning, the president can't dictate in any way how a state runs its election laws, and the president can't even make a law regarding anything that's related to election law, or the president can't just make a law, period.
And as you said, these EOs that he keeps churning out, they are just letters, memorandums, but he is trying to enforce them as though they were laws. And there are some people, even in Congress and in the state houses, who are giving assist and also trying to treat them as if they are laws.
Right.
How do we deal with that? Like, how does the citizenry oppose that?
Well, if a state actually tries to mandate some of his executive order, they'll be sued. That'll be resolved in court rather quickly. There'll be an injunction. There might be some organizations that are suing right now once it was filed because it can't be executed. It's unconstitutional to states and it's federally unconstitutional, most of his executive orders. This guy in the White House right now has more injunctions against him than any other president in history. So let me pivot though.
Okay.
Because I want to be careful about this to make sure that we look at it in context. Trump is not doing stuff that no president ever tried to do because every president has tried to expand upon their executive power. Obama, Bush, Biden, Bush 1, Reagan, Clinton, Carter, every single president tries. This has been the most egregious president not following the law, though. Other presidents try, like for instance, Biden trying to expand upon his executive reach with student loans under the HEROES Act. And he got checked by the Supreme Court. Whether you agree with the Supreme Court or not, he still tried to do something that probably he couldn't do that wasn't articulated in the Heroes Act, actually. And the Supreme Court actually even said that, like, you can't do it this way, but you could do it another way. And that happens
And he
sometimes.
went back around and said,
He
okay.
went back around and he did it under the 1973 Education Act. So some Education Act. I think it's from 73, but I could be wrong there. But he did it under that, which he always had the power to do. I actually didn't think he had the power under the Heroes Act to do it.
And you said that.
Right.
You have mentioned that a few times. So, and I love that you read the law. It's not partisan. It is the law, the rule of law, the book of laws that we were founded on. And I love that you take that approach when you're explaining things. It's important.
I always do. And some people don't like it. And in some cases they don't like it. But I get involved in some of these cases that I just find amusing and interesting too. I don't know that they're big, but I got involved in the Tory Lanez Meg Thee Stallion case just because I made a comment and someone made a comment back and I was like, wait, I know what I'm talking about. The judge in that case was my mentor. So I was able to comment on, like, I know the judge. I don't know what he was going to rule or anything like that, but I was able to give some insight into what he might be thinking and how he rules on a case. I was pinpoint accurate.
You were. And we talked about that in our first interview.
David doesn't change. Yeah, he has never changed. And, like, he's one of those people that taught me to take my emotion out of law. And, like, that's how you win. When you're in front of the court or when you're making argument, like serious argument legally, I take my emotion out of it. Unless somebody's just really stupid and they offend me. Sometimes these kids on Twitter, they're just talking mess. And they're like, what do you know? I'm like, well, actually, I can lecture about this. I don't want to pay Elon Musk for more space. It's a challenge to put responses in 280 characters at one time, but I find a way to do it. Then I get on your show and talk on Advocacy Arena.
I love it, and I think we're all made smarter by it. It is important because we are at a place and time where the electorate, our populace, the masses, things have been kind of dumbed down. We are experiencing this long-running, ongoing information war. As you said, the minister propaganda is what is being fed. And if people don't have access or seek good information, accurate information, it just gets us further and further away from where I think we need to be. That is one of the things that he is able to capitalize upon, is the lack of understanding, the stupidity, and I just mean lack of knowledge, the ignorance of some of these people and the cult-like adherence and behavior that his base, you know what I'm saying.
Yeah. One of the topics that I think you sent and I want to talk about too, I think we have to talk about this. I've been talking about this, honestly, for about 2 years. I've been talking about Amy Coney Barrett. I think that people need to start looking at Amy Coney Barrett differently. And I get laughed at a lot until the next opinion comes out and they're like, damn, Mark, you talked about that.
Thank you for listening to Connections and Conversations. This is one of many wonderful interviews that we bring to you to help connect you to a larger community of advocates and changemakers across the country. You'll get a glimpse into the various ways people are making an impact in their communities. My hope is that it will inspire you to get engaged in some small way as well. We can't all do everything, but at this moment in history, we can all do something. What are you doing? One of the things you can do is to continue to listen, subscribe, and share this Advocacy Arena podcast. You can also join and support the growing grassroots Advocacy Arena community in other ways. Join our weekly live chats hosted on Spoutable every Monday at 12 p.m. Eastern. Subscribe to our Substack to get great articles on important topics and exclusive access to extended interview conversations. And don't forget to subscribe to our YouTube channel as well. We've got some exciting programming lined up. And keep listening to our regular podcast episodes wherever you get your podcasts. And of course, subscribe and give us that all-important 5-star review.